That'll be live on C-SPAN 3 this afternoon at 1:30. And right now, Sabrina Fulton, the mother of Trayvon Martin, is among those testifying on so-called stand-your-ground self-defense laws and calling for states to clarify their standards, which vary and are applied inconsistently, according to some. This hearing has been underway for about 30 minutes. Now live coverage here on C-SPAN.
When young Trayvon reasonably sought to defend himself, and all because I strongly suspect that Mr. Zimmerman could not apprehend any lawful reason for a young black male to be walking through his middle-class neighborhood. To Mr. Zimmerman, Martin's blackness likely served as a crude proxy for criminality. Now, this unfortunate outcome sends a twofold message. First, it tells Floridians that they can incorrectly profile young black children, kill them, and be protected by stand-your-ground laws. But second, this decision sends an even more ominous message to young black children. So I consider myself fortunate to live in a jurisdiction that does not have stand-your-ground laws. But what if it did? I have an African-American son who's just shy of his 13th birthday, whose name, ironically, is Trey. What advice would I give him? I regret the only responsible advice if I lived in a stand-your-ground jurisdiction would be that if he ever felt seriously threatened by a stranger, then he would have to use all reasonable force up to and including lethal force in order to protect himself. Because I'd rather my Trey be alive and able to argue that he stood his ground than dead and portrayed by lawyers, the media, and present company excluded politicians as some stereotypical black male criminal. This is not a desirable America for anyone, and I don't want my son growing up in such an America. I respectfully suggest that states pass laws that permit police to police and citizens to go about the business of building communities. Thank you.
Thank you, Professor Sullivan. Our next witness is David Laban. Mr. Laban is the president and CEO of the Association of Prosecuting Attorneys, a national association representing elected deputy and assistant prosecutors. Previously, he was director of the American Prosecutors Research Institute and executive director of the California District Attorneys Association. He was also a deputy district attorney in Orange and Humboldt counties in California. He's a graduate of Cal State Fullerton and received his JD from Western State University. Mr. Laban, please proceed.
Good morning, Mr. Chairman, Ranking Member Cruz, and members of the subcommittee. Thank you for the opportunity to testify before you today. My name is David Laban. I'm the president of the Association of Prosecuting Attorneys, a private nonprofit mission whose support is to support and enhance the effectiveness of prosecutors in their efforts to create safer communities. APA is the only national organization to represent and include appointed, elected, as well as their deputies and assistants. On behalf of APA, I am pleased to have the opportunity to address the issues surrounding this vast expansion of self-defense referred to as stand your ground. As prosecutors, we seek to do justice for victims and hold offenders accountable for their actions, especially in cases where life has been violently ended, whether by firearm or other deadly means. Since 2009, APA has tracked the legislative progression of stand your ground and assisted prosecutors who have been working to enforce these expansive new laws. I have attached to my testimony our statement of principles regarding the stand your ground laws. These laws have raised a number of troubling and dangerous concerns. Prosecutors and their professional associations have overwhelmingly opposed stand-your-ground laws when they were in their respective legislatures. The concerns expressed included the limitation or even elimination of prosecutors' ability to hold violent criminals accountable for their acts. However, even with this opposition, many states have passed stand-your-ground laws. Many of these laws included provisions that diminish or eliminate the common law duty to retreat, change the burden of proof regarding reasonableness to a presumption, and provide civil and criminal immunity. By expanding the realm in which violent acts can be committed with the justification of self-defense, stand-your-ground laws have negatively affected public safety and undermined prosecutorial and law enforcement efforts to keep communities safe. They've undermined standard police procedures, prevented law enforcement from arresting and detaining criminals, stymied prosecutors, deterring them from prosecuting people who claim self-defense even when killing somebody in the course of unlawful activity. In some states, courts have interpreted the law to create a new procedural hurdle in the form of immunity hearings, which effectively transfer the role of the jury over to the judge. Moreover, because these laws are unclear, there's been inconsistent application throughout the states and even within their respective states. Prosecutors, judges, police officers, and ordinary citizens have been left to guess what behavior is legal and what is criminal. Even with the best efforts to implement these broad measures, defendants, victims' families and friends, investigators, prosecutors, defense attorneys, trial courts, and appellate courts have been forced into a case-by-case analysis with no legal certainty as to what they can expect once a life has been taken. Stand your ground laws provide safe harbors for criminals and prevent prosecutors from bringing cases against those who claim self-defense after unnecessarily killing others. For example, in February of 2008, a Florida case, a drug dealer by the name of Tavarius China Smith killed 2 men in 2 separate incidences, the first drug-related, the second over retaliation. Though he was engaged in unlawful activity in both instances, prosecutors had to conclude that both homicides were justified under Florida's Stand Your Ground law. Unfortunately, this example is not an anomaly. A recent study concluded the majority of defendants shielded by Stand Your Ground laws had arrest records prior to the homicide at issue. Stand Your Ground expansion began in Florida in 2005. It is our position that common law sufficiently protected people's rights to defend themselves, their homes, and others. The proper use of prosecutorial discretion ensured that lawful acts of self-defense were not prosecuted, and I have not seen evidence to the contrary. After reviewing the legislative history of the Florida provision, the very case used to justify this broad measure, it involved no arrest or prosecution. The law enforcement community responded properly to the shooting, and the homeowner was never arrested or charged in his lawful exercise of self-defense. Because the provisions of Stand Your Ground laws vary from state to state, I will attempt to summarize some of the provisions which have caused prosecutors difficulty in uniformly enforcing law. First, the meaning of unlawful activity needs to be clarified. Many states have extended Stand Your Ground protection to people who are in a place where they have a right to be and not engaged in a lawful activity. Can a drug dealer defend his open-air drug market? If an individual is a felon, does he have a right to kill another with a firearm? Second, immunity is rarely granted in criminal law, with a few exceptions existed in order to encourage cooperation with law enforcement and the judicial system. The legislature should remove the immunity provisions and clarify that self-defense is an affirmative defense. Third, the replacement of presumptions with inferences will eliminate many of the dangerous effects. This, coupled with an objective rather than a subjective standard, will improve accountability while protecting the right of self-defense. Fourth, the statute should be amended to prevent an initial aggressor from claiming self-defense. Some laws allow a person to attack another with deadly force and later use Stand Your Ground to justify killing the person he or she attacked if that person responds with like force and the initial aggressor cannot escape. Finally, we recommend that the law be limited so Stand Your Ground cannot be raised when the victim is a law enforcement officer, regardless of actual knowledge. Statutes should be amended to read that Stand Your Ground should not be applicable against a law officer only acting within the course and scope of their duties. Taken together, I believe these reforms to the various Stand Your Ground laws will help minimize their detrimental effects and restore the ability of investigators and prosecutors to fully enforce the law, promote public safety, while continue to respect the rights of law-abiding citizens to protect themselves and their families. Thank you, Chairman, for holding this hearing. And as I've been sitting here, I do want to reflect the decision to take life is one of the most solemn decisions any person can ever raise or be faced with. It should not be taken lightly. Public policy should not encourage one to violently take the life of another. Once that event occurs, and having prosecuted cases and dealing with the victim's family here, both lives are forever changed. The individual who chooses to make the decision to take life, as well as the victim's family. Thank you.
Thanks, Mr. Laban. Our next witness is Ilya Shapiro. He's a senior fellow in constitutional studies at the Cato Institute. Previously, he was a special assistant advisor to the multinational force in Iraq on the rule of law issues and was an attorney in private practice at Patton Boggs. Mr. Shapiro received an undergraduate degree from Princeton, a master's from the London School of Economics, and a law degree from the University of Chicago Law School. He clerked for Judge Grady Jolly of the Fifth Circuit Court of Appeals. Mr. Shapiro, please proceed.
Mr. Chairman, thank you for this opportunity to discuss the right to armed self-defense. It's most appropriate that this hearing was originally scheduled for September 17th, marking the anniversary of the Constitution's signing. On that day, public schools have to teach about our founding document. My organization, Cato, which thankfully isn't publicly funded, celebrates Constitution Day by releasing our Supreme Court review. In reality, however, every day is Constitution Day, so please excuse me if I have to leave early to travel to the National Constitution Center in Philadelphia to discuss the constitutional issues attending the debt ceiling debate. Now, Stand Your Ground is tremendously misunderstood. All it does is allow people to defend themselves without having a so-called duty to retreat. That concept has been part of U.S. law for over 150 years. About 31 states, depending how you count, now have some type of Stand Your Ground doctrine. The vast majority in common law before legislators took any action. Some, like California and Virginia, maintain it without any legislation still. Of the 15 states that have passed Stand Your Ground since 2005, a majority had Democratic governors, including Jennifer Granholm, Janet Napolitano, and Kathleen Sebelius. Louisiana and West Virginia passed them with Democratic control of both houses. Even Florida's supposedly controversial law passed the state Senate unanimously and split Democrats in the House. When Illinois strengthened its long-standing law in 2004, State Senator Barack Obama co-sponsored the bill that was then unanimously approved. Conversely, many so-called red states impose a duty to retreat. And even in more restrictive states, courts have held that retreat isn't required when preventing serious crime. Indeed, it's a universal principle that a person can use force when she reasonably believes it's necessary to defend against an imminent use of unlawful force. Where there's no duty to retreat, as in most states, she's further justified in using deadly force if she reasonably believes it necessary to prevent death or great bodily harm. The Florida law is no different. It's not an easy defense to assert, and it certainly doesn't mean that you can shoot first and ask questions later. These laws aren't a license to be a vigilante or behave recklessly. They just protect law-abiding citizens from having to leave a place where they're allowed to be. That's why this debate isn't new. In ancient Britain, when the deadliest weapons were swords, a duty to retreat greatly reduced blood feuds. British law reflects a deference to the constabulary, by which the king owed a duty of protection to his subjects. That's obviously not part of our tradition. Despite what gun prohibitionists claim, the no-retreat rule has deep roots in American law. At the Supreme Court, it dates to the unanimous 1895 case of Beard versus United States, which Senator Cruz quoted. In places with the duty to retreat, crime victims can be imprisoned just for defending themselves. That's controversial. A mugger can't have your wallet, but he can make you leave a public place. Among those harmed by the duty to retreat are domestic violence victims who turn on their assailants. Feminists thus support Stand Your Ground and point out that you could have run away may not work when faced with a stalker. Stand Your Ground laws are thus designed to protect law-abiding citizens. That's how we have the Castle Doctrine, which essentially all states recognize, most extending the doctrine to public spaces as well. It's bad enough for an innocent person to find herself threatened by a criminal, but to then have to worry about whether she can retreat lest she face lawsuits is too much to ask. As the progressive Justice Oliver Wendell Holmes wrote in the 1921 case of Brown versus United States, quote, detached reflection cannot be demanded in the presence of an uplifted knife. Nearly a century later, we shouldn't demand more of crime victims. Of course, any self-defense rule bears the potential for injustice. For example, in a two-person altercation, one may be dead and the other dubiously claims self-defense. These cases, like Trayvon Martin's, implicate the self-defense justification generally. If George Zimmerman was the aggressor, then he has no self-defense rights at all. If Trayvon attacked Zimmerman, then the only question is whether Zimmerman reasonably believed that he was in danger, not whether he could have retreated. And if Zimmerman provoked the confrontation, he lost the protections of Stand Your Ground law. In short, hard cases make skewed policy debates. This committee is well familiar with that demagogic dynamic after Sandy Hook. While anti-gun lobbyists have used both that tragedy and Trayvon Martin to pitch all sorts of gun control laws, what they really target is the right to armed self-defense. With Stand Your Ground laws, yes, prosecutors need to show evidence to counter claims of self-defense, not simply argue that the shooter should have retreated. For those who value due process, which should include historically mistreated minorities, that's a feature, not a bug. Finally, I should mention one episode that's contributed to the sensationalism surrounding this debate, the attempt to intimidate organizations with any ties to the American Legislative Exchange Council. Accordingly, I've submitted with this statement Chairman Durbin's letter to that effect and the response by Cato's president, John Allison. Thank you for having me. I welcome your questions.
Thank you, Mr. Shapiro. Our next witness is John Lott. Mr. Lott is the president of a newly formed organization, the Crime Prevention Research Center. He previously served in research or a teaching position at the University of Chicago and Yale, among other schools. He was the chief economist at the U.S. Sentencing Commission from 1988 to 1990. He's currently a weekly columnist and contributor for FoxNews.com. He received his Ph.D. in economics from UCLA. Mr. Lott, please proceed.
Thank you very much, Chairman Durbin and Ranking Member Cruz and other distinguished members. Stand Your Ground laws help people. Oh, I apologize. Thank you very much for being here. Stand your ground laws help people be able to defend themselves. It's the people who are most likely to be victims of violent crime, primarily poor blacks, who benefit the most from having the option to be able to protect themselves. What's been lost in part of this discussion so far is the reason why states have adopted these laws. Requiring people to retreat as far as possible creates confusion, creates doubt, and can make it more difficult for people to be able to go and defend themselves. In Florida, blacks made up about 16% of the population, but they account for 31% of the state's defendants invoking stand your ground laws. Black defendants who invoke the statute to justify their actions are actually acquitted almost 8 percentage points more often than whites. The Tampa Bay Tribune has put together very detailed data on stand your ground cases. Up through July 24th of this year, from beginning of 2006, the newspaper had collected 112 cases. The information that they had that often constitutes their shocking finding is that 72% of those who killed a black person faced no penalty, compared to 59% of those who killed a white person. 80% of those who killed Hispanics were also not convicted. What one needs to remember, however, in this is that the vast majority of these crimes are within race. So, for example, 90% of blacks who were killed in stand your ground cases who invoked stand your ground were killed by other blacks. In the case of whites, it was 85%. In the case of Hispanics, it was 100%. The basic point is that if you're going to concentrate on the fact that relatively few people who kill blacks are going to be convicted using stand your ground defenses, you have to realize that almost all those people who aren't being convicted are blacks. 69% of blacks who raised the stand your ground defense were not convicted. That compares to a little bit less than 62% for whites. 80% of Hispanics who raise the stand your ground defense are not convicted. If blacks are supposedly being discriminated against because their killers so often are not facing any penalty, wouldn't it also follow that blacks are being discriminated in favor of when blacks who claim self-defense under the stand your ground law are convicted at much lower rates than other racial groups? The problem also is not all these cases are the same. Blacks are killed in confrontations where were 13 percentage points more likely to be armed than whites. By a 43 to 16% margin, blacks killed by other blacks, were also more often in the process of committing another crime. They also were involved in cases where it's much more likely to have a witness present. If you go and run regressions where you try to account for all the factors that are brought up in the Tampa Bay Tribune data set, what you find is that white defendants are more likely to be convicted by black defendants, and people invoking stand your ground laws who kill blacks were also more likely to be convicted than those who killed whites. What you find when you look at it, and fortunately this is the case, the people who initiated the confrontation were more likely to be convicted, and when there were eyewitnesses, they were less likely to be convicted. Armed individuals, and when more than one person was killed, also were much more likely to result in convictions. The Urban Institute report that was brought up earlier, I think actually shows the opposite of what has been quoted here. One of the important things just to mention, John Roman, who wrote this, noted stand your ground laws appears to exacerbate, well, he said they appear to exacerbate racial differences, but he acknowledges his data lacks details available in the Tampa Bay Tribune data. Quote, the data here cannot completely address this problem because the setting of the incident cannot be observed. And if you go through his paper, what you find, he has no data, no information on whether an eyewitness saw the confrontation, no data on whether there was a physical evidence. He has no evidence on a whole range of things in order to try to factor those into account. The big thing, if you look at his study, the central finding is to look at Table 3. And what you find is that when blacks are under stand your ground laws, their situation in terms of conviction rates actually fall. If you look at the Texas A&M study that was mentioned, They do not account for any other gun control laws. If you're going to look at stand your ground laws, whether you have right to carry, the number of people who have permits is going to be important. And when you account for those things, their results disappear. If you're talking about castle doctrines, whether people are able to get quick access to guns is going to be important. And again, nothing about gun lock or safe storage laws are accounted for in those studies. And when you do that, their results also disappear.
Thank you, Mr. Lott. Our final witness is Lucia McBath. Ms. McBath is the mother of Jordan Russell Davis, who was shot and killed on November the 23rd, 2012, at a gas station in Jacksonville, Florida. Ms. McBath and Jordan's father, Ron, have become advocates for reducing gun violence. Ms. McBath is the national spokesperson for an organization known as Moms Demand Action for Gun Sense in America. She recently founded the Walk with Jordan Scholarship Foundation, providing assistance for graduating high school students. Ms. McBath is a graduate of Virginia State University, and before you say a word, I'd like to thank all the members of the panel for their patience in the rescheduling of this hearing. We had a chance to meet when it was previously scheduled, and I'm glad we did have those moments together. So please proceed with your testimony.
Thank you. Good morning, Chairman Durbin and honored members of the subcommittee. My name is Lucia Holman McBath, and I thank you for the opportunity to speak before this great institution today. I was raised in a family steeped in justice and confident in the triumphant goodness of humanity. My mother was a registered nurse, and my father, who served in the U.S. Army Dental Corps, was also for over 20 years president of the NAACP for the state of Illinois. He worked actively with President Lyndon Baines Johnson in the signing of the Civil Rights Act of 1964. If he could see me here today, testifying in front of the United States Senate, he would be beaming with pride and amazed at how far his daughter had come until he came to understand what brought me here. I appear before you because my son Jordan was shot and killed last November while sitting in the back seat of a friend's car listening to loud music. The man who killed him opened fire on 4 unarmed teenagers, even as they tried to move out of harm's way. That man was empowered by the Stand Your Ground statute. I am here to tell you there was no ground to stand. There was no threat. No one was trying to invade his home, his vehicle, nor threatened him or his family. There was a vociferous argument about music, during which the accused, Michael Dunn, did not feel that he was treated with respect. "You're not going to talk to me like that," he shouted as he sprayed the car that Jordan sat in with bullets, killing him instantly. When Jordan's friends tried to back the car away, Mr. Dunn aimed his handgun and fired off several more rounds, 9 total, pierced the car. There are any number of ways that this interaction might have gone, but there was only one way it could have ended once a gun entered the equation. In Florida, over 1 million people carry concealed weapons. Additionally, 10,000 to 15,000 more Floridians are approved to carry guns in public every month, faster than any state in the nation. Nationally, Florida has some of the loosest permitting requirements. Automobile glove boxes are becoming modern-day gun boxes. In his glove box, Michael Dunn kept a 9mm semi-automatic gun along with 2 loaded magazines. Once he had unloaded his gun at my son and his teenage friends, he immediately went back to his hotel, ordered a pizza, and slept. He left the scene and made no attempt to call police. He retreated, but only after he killed my son. The next morning, he was arrested 2 hours away. Those are hardly the actions and motives of someone who was quaking with fear. Some will tell you that the argument was about music, but I believe that it was about the availability of guns and the eagerness to hate. People like Mr. Dunn feel empowered to use their gun instead of their voice to reason with others. Now I face the very real possibility that my son's killer will walk free, hiding behind a statute that lets people claim a threat where there was none. This law declares open season on anyone that we don't trust for reasons that we don't even have to understand. They don't even have to be true. In essence, it allows any armed citizen to self-deputize themselves and establish their own definition of law and order. It lets one and all define their own criteria for right and wrong and how justice will be carried out. Even the Wild West had more stringent laws governing the taking of life than we have now. Stand your ground defies all reason. It goes against the sound system of justice established long ago on this very hill. My son was named for the Jordan River. In the Bible, that river symbolized the crossing to freedom. Its waters marked the final steps to liberation and offered up the holy stream that baptized Jesus. Its name seemed a fitting choice for a boy born at the end of the 20th century, a time when black people in this country had finally come into their own. Jordan was named for a change in the tide, a decision to try harder and do better. He was my only child. He was raised with love and learning and a clear understanding of right and wrong. I have been without Jordan now since Thanksgiving weekend 2012, without him last Christmas, and on his birthday in February. I never got to take his prom picture or see him graduate from high school. I can tell you all about him, about his easy smile, his first girlfriend, and his plans to join the Marines. I can tell you how he loved his dad's gumbo and how they both rooted for the New York Giants. But you can never really know my boy, because an angry man who owned a gun kept it close at hand and chose to demonstrate unbridled hatred one balmy evening for reasons I will never understand. These laws empowered his prejudiced beliefs and subsequent rage over my son's own life, his liberty and pursuit of happiness. There will be no sense made of any of it unless I and the families of other victims speak out to assure that this kind of predatory violence ends. It was 50 years ago that my father shook hands with Eleanor Roosevelt. She assured him of the validity of his struggle and the promise of better times. She, as he did, believed that this nation was righteous to the core, that we as a country would never stop striving to do better, and that's what was made us better. Honorable men and women of the Senate, you can prove them right today. With your help and willingness to bring our laws back toward the true tenets of justice, you can lift this nation from its internal battle in which guns rule over right. You have the power to restore hope to a nation crying out for justice. And I pray that you hear the will of the Lord. Thank you.
Thank you, Ms. McBath. We'll now turn to questions for the witness, and each member of the committee will have 7 minutes. I'll start. Ms. Fulton and Ms. McBath, thank you for your courage in coming here today. I find it hard to understand those who defend Stand Your Ground by arguing that African Americans should celebrate these laws. The notion that somehow this is to the benefit of African Americans or minorities in this country just defies the stories that we have been told by both of you. Innocent children killed in the name of self-defense, when in neither instance was there evidence of aggressive or violent conduct by these victims, these young men who were shot down. Professor Sullivan, you've heard these arguments made, 2 members of the panel and a member here, about this notion that somehow African Americans should view this as a positive thing on Stand Your Ground. What would you respond?
Well, I would agree with your statements, Senator Durbin. It's not a positive thing for anyone where citizens of the United States are running around shooting each other. Whether the perpetrator is African American, whether the victim is African American, it really doesn't matter. We do not live in a wild, wild west era any longer. Private law enforcement has a deleterious effect on our country, and we should leave it to trained police officials to engage in this sort of behavior.
Mr. Laban, your testimony, I read over last night and again this morning, and I was particularly moved by one section of it that I'd like to repeat. You stated, by expanding the realm in which violent acts can be committed without the justification of self-defense, Stand Your Ground laws have negatively affected public health and undermined prosecutorial and law enforcement officers to keep communities safe. You then go on and talk about a specific case in February 2008, which you mentioned in your testimony. A 29-year-old drug dealer named Tavarius China Smith killed 2 men in 2 separate incidents, the first drug-related, the second over retaliation for the first. Though he was engaged in unlawful activity in both instances, selling drugs during the first shooting, using an illegal gun in the second, prosecutors had to conclude that both homicides were justified under the Florida Stand Your Ground law. Unfortunately, you go on to say this example is not an anomaly. A recent study concluded that a majority of defendants shielded by Stand Your Ground laws had arrest records prior to the homicide at issue. Now, Mr. Laban, if we had called as a witness here a person representing the National Association of Criminal Defense Attorneys, maybe some people would have understood. Oh, I can see where they're going. But in your case, you represent the profession of those who prosecute criminals, and you are saying Stand Your Ground laws are not working to the benefit and defense of America. Tell me why you come to that conclusion.
Well, Senator, I think you gave that example, and I can give the committee additional examples and even more recent cases. But I'll start right away with your question about the National Association of Criminal Defense Lawyers. On behalf of APA, we work closely with the defense bar, and this is one of the areas that the 2 of our groups, we diverge. Why? Because this is good for the defense. When I testified down in Florida, there was a defense lawyer that was on the Scott Commission. He clearly said, this is good for the defendants.
Excuse me, you're saying the criminal defense lawyers were arguing that Stand Your Ground laws were good for criminal defendants.
Good for criminal defendants. That the role of the criminal defense attorney is to get their client off in the criminal action. However, the role of the prosecutor is to seek justice. So on behalf of the criminal defendants and defense lawyers, this is a good law. Look at the ambiguities that are here. Look at the specific examples. You talked about there about here's a drug dealer in an open-air drug market. Now, unfortunately, at the time of the killing, he was not selling. If he had been selling drugs, then it would be an unlawful activity. But he was just in a legal place he had a right to be, and he was not selling at that moment. Therefore, he had a right to defend himself. The second piece was, and as I mentioned in my testimony, is a felony possession. If someone is a convicted felon, they have no right to possess a firearm. Yet they can go ahead and Stand Your Ground and use, especially by Florida decisions, use that firearm and be free and not be held accountable. The stories are unbelievable. January of 2012, another Florida case. The victim was stealing. Now again, it's usually the victim of the shooting did something wrong. No question about that. But here in this situation, someone sees their car being burglarized. They go ahead, they chase, they yell at him, "Get out of my car." In this Florida situation, chased him down and knifed him to death. Then never reported, never called 911, never said anything about it. And then when confronted, said, "I was defending my property." The Texas example, November of 2007, the Horn case that was broadly disseminated out to the country. Gentleman looks and sees his neighbor's house being burglarized, calls 911 to report it. 911 urged them, stay in your house, we'll get him, we'll take care of it. No, instead, he goes ahead and shoots both of those two, and I believe there was juveniles dead, and then goes ahead and exercises stand your ground. And that went in front of the Harris County Grand Jury. The Harris County Grand Jury found that to be stand your ground. The movement here to create these presumptions and to give immunity. Immunity is crazy to be, that's not what it should be. It should be an affirmative defense. And that has caused these problems. So yes, on behalf of prosecutors, these acts have done nothing but cause us difficulty.
It appears that this law is an invitation for confrontation. That historically, and I think Professor Sullivan raised this point, if you could safely retreat, that was your duty, except in your home. The Castle Doctrine, I believe, made a clear distinction when it came to your home in that circumstance. But the new laws, the stand your ground laws, are an invitation to confrontation and presumption of reasonableness and civil and criminal immunity. Now I understand that the state of Florida is debating about changing these laws. Could either of you testify about how they would change their law and what they're raising as a reason for a change?
Well, I think they're raising as a reason for a change the fact that the law produces absurd results. So one of the things that they are thinking about changing is clearly establishing this principle of first aggressor and whether first aggressors can avail themselves of the law. Duty to retreat, if I can, Senator, is important because I've heard comments today that are plainly wrong with respect to what historically duty to retreat meant. And you said it meant safely retreat. It did not mean stand there foolishly and be brutalized because of some law. If it's unsafe to retreat, nowhere in our history is an individual required to retreat. Rather, only if it's safe to retreat. This is just a norm of good judgment, the exercise of good judgment, a norm that prevents the sort of vigilantism that we see in these many cases that were cited. Finally, I think Florida, to answer your question, should tweak the immunity provision. Because my point is that immunity, along with the change in presumption, conditions a certain response in people. That is, people who know this law behave in a way, a much more aggressive, frontiersman-like way, that they would not, but for the broad, expansive protection of these laws, quite different from the historical self-defense laws, and even quite different from the stand-your-ground iterations historically. 2005 marked an extreme difference in the way that these laws were written.
Thank you, Mr. LeBon.
May also.
Mr. Chair, thank you. Responding to your question about Florida, the other significant thing that Florida is doing and has passed out of their committee is the immunity provision. They are working on there, and there was the civil portion to say that if someone sprays and kills a number of people in stand your ground, that they should not be civilly immune, especially hit an innocent bystander. Because I think it's significant, and as I shared, I testified in front of that commission, and now they're stepping forward and changing what's a flawed law. May I add one other comment, sir? It was William Meggs, who was unable, he's the second judicial circuit prosecutor out of Florida. He was unable to attend today, but he had been in the initial one. His closing comments, I think, are so very, very important. And that was his, shouldn't we have a duty to act reasonably towards one another? That was the law before Stand Your Ground, and which is why the law should return. The bottom line is that this is an unnecessary law which makes it easier for the worst criminals to get away with some of our most heinous crimes. So yes, that's why on behalf of prosecutors I stand here today.
Thank you. Senator Cruz.
Thank you, Mr. Chairman. At the beginning, I'd like to enter into the record a statement from the senior senator from Texas, Senator Cornyn.
Phillips.
I'd like to thank each of the members of the panel for being here, in particular Ms. Fulton and Ms. McBath. Thank you for being here. Thank you for sharing your stories. Every parent understands the mourning you are feeling, and it is always a tragedy when a child loses his life. And please know that we are all feeling your loss and express our very sincerest condolences. Much of the discussion this afternoon has concerned the tragic circumstances of the Trayvon Martin case. And none of us in this hearing room were there that night. None of us knows precisely what happened. We do know that there was a violent altercation between an Hispanic man and an African-American teenager. And we know that at the end of that confrontation, the teenager was dead. What exactly occurred that night, no one in this room likely will know for sure. But we do know some things. We know that our system of justice has a process for ascertaining what happens when there is a violent confrontation, particularly one that leads to the loss of life. And that process is a jury trial. And a jury of Mr. Zimmerman's peers heard the evidence in that case. He was prosecuted in that case. And the jury rendered a conclusion. We don't know if the jury was right or wrong, but we do know that the jury system is the only system that our judicial system has for ascertaining what happened, particularly when you have a one-on-one confrontation. It can be particularly difficult to determine what the facts are. But we also know that the subject of this hearing, the Stand Your Ground laws, was not a defense that Mr. Zimmerman raised. So this entire hearing, the topic of this hearing is not the issue on which that trial turned. And sadly, we know that some in our political process have a desire to exploit that tragic, violent incident for agendas that have nothing to do with that young man who lost his life. We have seen efforts to undermine the verdict of the jury, and more broadly to inflame racial tensions that I think are sad and irresponsible. I recognize that for the family, you're simply mourning the loss of your son, and I understand that. But there are other players who are seeking to do a great deal more based on what happened that Florida night. I would note additionally that the chairman of this committee a moment ago made I thought, remarkable statement that to the effect that no one could reasonably believe that Stand Your Ground laws protect those in the African American communities who are victims of violent crime. I think that's a remarkable statement on many, many fronts, including the fact that a great many African Americans find themselves victims of violent crime and have asserted this defense to defend themselves, defend their families, defend their children. But I also find it remarkable because the assertion that no one reasonably could suggest this benefited the African American community is drawn into remarkable relief when one keeps in mind that in 2004, a state senator in Illinois by the name of Barack Obama co-sponsored an expansion of Illinois' law providing civil immunity for those who use justifiable force to defend themselves. So the notion that stand your ground laws are some form of veiled racism may be a convenient political attack, but it is not borne out by the facts remotely. I want to secondly note the issue of ALEC, an organization that exists to encourage common sense legislation in state legislatures. I would like to enter into the record multiple letters that have been submitted to me by organizations that are concerned about the targeting of ALEC in conjunction with this hearing. And I would note that it should always be a concern when you see the United States Senate targeting the exercise of free speech. This observation is not unique to me. Indeed, on August 8, 2013, the Chicago Tribune wrote an editorial that stated free speech isn't always free. It gets downright cumbersome when senators have you on their enemies lists. And it would be wrong for a U.S. senator to use the power of his high federal office as a cudgel against his enemies. And I certainly hope that this Senate hearing does not become an avenue to suppress free speech. A final point I'd like to make. By its definition, the stand